Lawyers. Has there ever been a time the opposing counsel accidentally proved your case for you and what happened? Story 1. I had a hearing where the opposing party offered an updated contract that my client supposedly signed, except it was a horrible copy and barely readable. Then he assured the judge that the new contract was exactly the same as the old contract, except for the party name at the top. The original contract was in his mom's name, the new one in his name, and the date of the contract itself. He made that assurance multiple times. After he exhausted himself saying how everything was the same, I then pointed out to the judge that half the provisions were different and that my client had never signed that form. The judge asked if we were really accusing him of forging my client's signature, since that's a serious accusation. I held up the guy's prior conviction for contract fraud and said, "I absolutely am, Your Honor." We won. Hands down. No further argument needed. Dium. Not a lawyer. I once had an individual accuse me of HIPAA violation. Sat at a meeting with hospital folks ready to give me talk before the case moves forward. She started small talk and I said, "Can we please get to the matters at hand?" Then she starts, "Blah blah HIPAA blah blah." Me. "Thank you. I fully understand the gravity of the accusation. Can you specifically outline why I cannot share this information with said individual?" Then she starts reciting BS hospital policy. I cut her mid-sentence and said, "Here's the document the patient signed that specifically outlines my ability to share this information with said personnel." Amazing how 3 checkpoints failed to look at the damn document, and there I was sitting in a meeting wasting time. She let me walk out after that and told me that she'd take care of the situation. Felt like a total boss. I imagine you felt 100x cooler after the "I absolutely am, Your Honor." Haha. Story 2. My dad's ex-girlfriend took us to court over his estate after he kicked her out. Her claim was that she was entitled to half the pie due to de facto marriage. Our claim was that she was a gold-digging whore who planned it from the beginning. She had mountains of evidence of her contribution to Dad's company and running the private estate. Expense reports, receipts, dates and times her and Dad proved their relationship with trips and combined spending, etc., etc. She had so much evidence, the judge took 4 days to look it all over. After which he came back and basically said, "Why the hell would you have all of this if this wasn't your plan the whole time?" The case was very downhill from there. Story 3. I had a misdemeanor possession case I was defending. Client was driving his mom's car. He gets pulled over for playing the stereo too loud. There are pills in the center console, in a prescription pill bottle. The bottle has his mom's name on it. Client gets arrested and charged with possession of a controlled substance without a prescription. Case is obviously bullshit, but the dumbest DA I've ever met in my life won't dismiss. We go to trial. During closing arguments, the DA says, "This case is a circumstantial evidence case." During my closing, I slap the jury instruction on the projector that says, "If a case is based on circumstantial evidence and there is one factual scenario that points to guilt and one that points to innocence, the jury must find in favor of the defendant and acquit." My client was acquitted. Story 4. Not a lawyer, but was taken to court once. A guy had taken my family to court, basically he had been dating my mother, and things ended. So he then takes us to small claims court with an itemized list of everything he'd ever bought the entire family. Every cheeseburger, every Kit Kat. He even billed for things he did, like house repairs. Some of the repairs were terrible and ruined other things. He tried to unclog the sink and ended up destroying the main drain pipe for the house. Now, he had bought some more expensive things as well. No one asked him to, but he was one of the types that loved to show how much money he had and would always talk about his connections and would name drop someone anytime we went anywhere. So when he takes us to court with his full itemized list, the judge asks him to go first and present his testimony. He basically says, "While I was with them, I bought all this stuff. I took them to dinner all the time and all this. But it was the idea it would be paid back by them." Judge: You bought a child a birthday cake with the idea it would be paid back? Did you ever say that these things were loans and not gifts? Him: Well, no, but I shouldn't need to. That's the normal way people think. Judge: Well, that's not the way I'd think. Case dismissed. Story 5. I had to go to court over a financial cock-up when I was a student. Took advice from the university legal support team who said I didn't need a solicitor, so I went in alone. The judge didn't like this, and postponed it for another date so I could prove I'd had more counsel first. The other party's solicitor caught me outside the court and said, "I didn't tell you this, but," and pointed out a huge error in the financial paperwork that made it very obviously come out in my favor. Went back to legal support, got confirmation that it was right, went to the second hearing alone and got the entire thing thrown out. The other solicitor winked at me as he left. Saved me about $9K. Nice chap. Story 6. Not a lawyer, but a relative of a retired prosecutor. Relative was working misdemeanor criminal court. Cases get called in alphabetical order, and 2 women named Catherine Smith and Catherine Smith were scheduled to have their hearings before the judge. Not their actual names, but you get the point. Both had similar crimes, but slightly different. So the bailiff announces the next case to the courtroom. Catherine Smith, for 1 count of possession of cocaine with the intention to sell, and 1 count of prostitution. So Catherine Smith stands up and indignantly cries, "Whoa, whoa, just wait a second. Where the hell did the prostitution charge come from? I may deal crack, but I am not a whore." Easiest drug dealing case my relative ever prosecuted. Story 7. Not a lawyer, but here's a story from the burbs. My buddy is in the middle of a situation like that right now. His psycho neighbor built a wall too high and doesn't have proper drainage on his property for the very small creek, natural drainage in between their yards. My buddy hired an attorney, as the psycho decided to sue him over it. My buddy's engineer that looked over the property noted, not only did my buddy set his yard up right, but the neighbor created drainage problems. Neighbor hired his own engineer. That proved my buddy was correct. Now the guy is likely to go postal. Case was going to go to mediation. Since both engineers found fault with the psycho neighbor, my buddy decided he's going to take it to trial. Turned the tables a bit. We'll post a follow-up if I can find this thread after the trial wraps. Story 8. My favorite is a story from Jerry Spence. For those who don't know, he is a famous trial attorney. A witness on the stand was claiming that he had suffered injuries to his arm because of a city bus accident. Jerry asked him to demonstrate to the jury how far he can lift up his arm after the accident. The witness makes a feeble effort of lifting his arm. Then Jerry asks the witness to demonstrate to the jury how far he could lift up his arm before the accident. He lifts his arm much higher. The jury laughs. The case is over. Story 9. I am not a lawyer, but witnessed a pathologist win a case in court by destroying the defense's credibility. The question was over whether or not carbon monoxide poisoning could have caused certain signs of death in an individual. But the defense didn't study their chemistry very well, and kept asking the pathologist whether carbon dioxide could have caused these signs. After thoroughly frustrating the defense by answering his questions incorrectly, the pathologist said very loudly, "Oh, I'm sorry, did you mean carbon monoxide? Because that's a completely different thing." Completely destroyed the defense's credibility in front of the jury. They were done after that. So I guess the opposing counsel screwed himself by not picking up a book. Story 10. I worked as an intern for a lawyer. Construction law, in France, are quite strict in regard to the neighboring of historical monuments. The city was denying a permit for heavy modification of the house of our clients. They were arguing that because you could see the house from the church's bell tower, modifications were impossible. As a support, they kindly linked us to a 360-degree picture from said bell tower. We, as kindly, pointed to them that our client's house was, indeed, not visible from the top of the church. Building permit was greenlit the following day.